Please rise. Iku Iluna. Ahea o ko e ko ka aha, inahe kuliana o imua o kea aha, ho o kolo kolo ki e ke hano hano, o ka moku aina o Hawaii. E naoi mai, e malio mai, I lohe ia ka leo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give you attention and you shall be heard. E noho I lalo. Please be seated.
All right, please call the case.
Case number SCPW-24-0000537. Hawaii Police Department, County of Hawaii, Petitioner versus the Honorable Peter K. Kubota, Judge of the Circuit Court of the Third Circuit, State of Hawaii, Respondent Judge, and Albert Ian Schweitzer, Sean Schweitzer, and State of Hawaii, Respondents. Arguing for Petitioner, Hawaii Police Department, Britt Bailey. Arguing for Respondent, Albert Ian Schweitzer, Jennifer Brown, and William Harrison. Also appearing is Richard Freed. Arguing for Respondent, Sean Schweitzer, Keith Shigetomi. Arguing for Respondent, State of Hawaii, Shannon Kagawa. Argument on the merits.
All right, good morning, aloha, everyone. Our proceeding today is being broadcast live on the Judiciary's YouTube channel, as well as on Olelo. Counsel, are you all ready to proceed today? All right, very well. We've allocated 1 hour for oral argument. We'll begin by hearing from Ms. Bailey and Ms. Kagawa in support of the petition. Ms. Bailey, you'll have 10 minutes in your initial argument, 7 minutes reserved for rebuttal. Ms. Kagawa, 10 minutes in your initial argument, 3 minutes for rebuttal at the end. Ms. Brown, Mr. Harrison, and Mr. Shigetomi will all have 10 minutes, and we'll give everybody a warning light with 2 minutes to go. So I couldn't have made that much more complicated, but I think we'll be able to figure it out. So we're very excited to hear argument today. Please proceed.
Good morning, Chief Justice Rechtenwald, Associate Justices. I'm Britt Bailey, Deputy Corporation Counsel on behalf of the Hawaii Police Department, County of Hawaii. Here today also with me is Chief Benjamin Moskowitz and Deputy Chief Reed Mahuna. I very much appreciate the opportunity to be here with you today and discuss this matter. On August 1st, 2024, the Office of Corporation Counsel was served with a subpoena ducis tecum to the Hawaii Police Department requesting law enforcement records pertaining to an ongoing active criminal investigation related to the recent developments in the matter of Dana Ireland. This is the same day that the Hawaii Police Department entered an appearance in the Hawaii Rules of Penal Procedure, Rule 40 Special Proceedings for Albert and Sean Schweitzer. The Hawaii Police Department respectfully requests that this court issue a writ of mandamus directing the lower court to quash the August 1st, 2024 subpoena and/or maintain the confidentiality of the requested law enforcement records related to the active, open, and ongoing investigation into the death of Dana Ireland. The subpoena ducis tecum is unreasonable and oppressive and would frustrate a legitimate government purpose. The law supports maintaining the confidentiality of the records at this time. Specifically, the Uniform Information Practices Act, Chapter 92F, protects the requested records from public disclosure, which the lower court stated would happen. The current investigation is real. In fact, as we speak, as I stand here today, the Hawaii Police Department is actively working on this investigation. It is interviewing witnesses, it's analyzing electronic data, it's awaiting the results of tests, and it's awaiting reports. The Hawaii Police Department has a duty to investigate.
You and interviewing who? I mean, I want to know what's left that needs to be investigated, because you say ongoing investigation, not to disclose it at this time. What is it about at this time that precludes any disclosure given what the Schweitzers have gone through?
Thank you for your question. And I hope you can recognize that I don't want to divulge too much of the investigation at this time for the same reasons that I'm before you today. But what I will let you know is that family members have yet to be interviewed, or at least the completion of those interviews. Mr. Lauro's wife has not made herself yet available for an interview.
Are there other possible suspects out there that the department is trying to track down? Accomplices, co-conspirators?
There certainly could be. And with a full...
Are there any leads, though, at this time?
At this time, I'm not aware of any leads, but the interviews have not been completed.
Are the Schweitzers still suspects?
I cannot answer that question.
I'll take that as a no.
I will... Let me qualify that. I would not say that the Schweitzers are not still suspects.
Well, you folks filed a joint stipulated facts and agreed to all those facts, and all the facts exonerated them as far as the way I read it. You folks submitted it as a joint stipulated fact.
I work for the Office of Corporation Counsel. I've not been involved in any of the underlying Rule 40
Talking about from the
proceedings.
state side.
Yes, there are
Prosecutor
stipulated
side.
facts, correct. And those indictments have been, certainly the indictment for Sean Schweitzer and Albert Schweitzer have been vacated.
And I would think that if the police department disputed any of those facts, they would have raised a voice about it, but they didn't. Is that correct?
Again, I will defer that question to Ms. Kagawa, who was present during all of the process of those stipulated facts, yes.
Thank you.
Thank you.
You know, you've recited some, what I deem as some facts with respect to the ongoing investigation that you and the prosecutors deem is going forward. But with the motion to quash, the declaration that accompanied that sort of just pretty much had boilerplate language. Don't you think that to combat a subpoena ducis tecum, that you need some specificity versus conclusory allegations, more specificity than was recited in the declaration from Captain Amon Wilkins?
If the investigation had not been in its infancy, perhaps. The motion to compel, which led to the subpoena ducis tecum, was filed on July 28th. Mr. Lauro passed away some days earlier. The investigation was literally in its infancy at the time that we received the subpoena ducis tecum, so it was very difficult to add specific details and or allegations when at that point the investigation had literally, certainly in terms of the recent developments, had literally just begun.
But you would agree, aside from, I guess, the posture of this particular case, that in general, there must be specific allegations or assertions with respect to an ongoing investigation?
I think that generally speaking, there needs to be specific facts, and I think that those were provided as best as they could be in the declaration of Captain Amon Wilkins, specifically at that time. I don't necessarily agree that there needs to be allegations.
And I wanted to shift a little bit back to some of your earlier remarks in your introductory. Now, you were basically, you referenced 92F, the Uniform Information Protection Act, and you're basically, I mean, it just seems to me that the UIPA does not restrict civil discovery, and rather it's really the right to request public records that may be restricted when there's a pending lawsuit. How does the UIPA, how do the exceptions really apply to civil discovery?
Well, first of all, to answer that question, I would have loved to have been involved in civil discovery. We would have raised these privileges in that process. Hawaii Police Department didn't come into this case until August 1st.
So you would raise the 92F privileges and not the HRCP framework?
We would have raised the HRCP framework had we been in civil litigation.
And not have raised the 92F?
Correct.
Because
I
that's
think
not
that
that's not applicable to this situation, right?
92F is operable in this situation. 92F12 does contemplate response to court orders and subpoenas.
But doesn't 92F3 clearly say that 92F does not apply to non-administrative functions of the judiciary? I mean, it doesn't apply to court proceedings. It applies to our administrative functions, but not to our non-administrative functions.
92F-12 does contemplate that it can be used in response to subpoenas as well as to court orders.
92F3 says agency does not include non-administrative functions of the courts of this state. 92F is not how we address whether or not discovery should be provided unless there's a privilege. So let me ask you, what privilege are you saying applies here?
What I would say is if we had been involved and HPD was a party to civil litigation and we received a written discovery request, we would have, under Rule 26, maintained that there's a qualified privilege under Mayhow versus Kealoha.
Mayhow versus Kealoha and those cases that you cite all came before the effective date of the Hawaii Rules of Evidence. Rule 501 of the Hawaii Rules of Evidence is very clear that it basically abrogates common law privileges unless a privilege is laid out pursuant to the Constitution of the United States or the Constitution of the State of Hawaii or a statute or under the Hawaii Rules of Evidence. There's no privilege. So what is the basis of your assertion of a privilege?
I would go back to Mayhow versus Kealoha. That's still good case law, and that they do recognize that there's a qualified privilege to maintain.
That's a common law privilege, which was abrogated by the Hawaii Rules of Evidence in 1980.
Correct. However, Mayhow versus Kealoha, as well as the Kaneshiro case versus Ao.
Kaneshiro is also referring back to underlying facts that occurred in 1977 before the effective date of the Hawaii Rules of Evidence.
I think in answer to Justice Eden's question as well as this, which are clearly related to a discovery process, like I said, I think the Hawaii Police Department would have been happy to be involved in a discovery process where we received a written discovery request.
Is there a statutory privilege that you would have invoked?
I think the exceptions under 92F in this particular
Aside from 92F?
Is there a statutory privilege? No.
Evidentiary.
There is a recognized law enforcement privilege that's found in Mayhow versus Kealoha. It's
Talking
found
about
in
a
Kaneshiro.
statute, an HRS statute.
There is not an HRS statute specific to this law enforcement privilege that we're recognized. Or
In fact, there's a
exists.
privilege that relates to the identity of confidential informants. So in the Hawaii Rules of Evidence. So the Rules of Evidence as adopted by the legislature have been very narrow in what they've authorized.
Correct.
So what's left of Mayhow? And if that case is questionable in light of the adoption of the Rules of Evidence, what will your position be regarding discovery under our rules of civil procedure? Could there be a protective order? Should there be? How long could it last?
I absolutely think there should be a protective order. And we actually wanted that in this particular case. Certainly 92F would apply to any public disclosure of these criminal investigatory records.
Counsel, before you step down, I see your time is short. You talk about an active ongoing investigation at this time. And, time has passed since you've been before the Third Circuit Court. And I'm wondering what, if anything, you can share in terms of how long that active ongoing investigation needs to be. Are you able to share anything on that?
I am, and Ms. Kagawa can better address that as well. But I did speak to Captain Ammon Wilkins yesterday, just to ask him that specific question, like what's going on now? Is this still an active ongoing investigation? He said it very much is. They're still in the process of interviewing witnesses. They're still in the process of awaiting the results of certain reports, for example, the autopsy report, and they're still doing the cell phone analysis. There are other ongoing pieces to the investigation which I don't feel comfortable divulging at this time. But yes, as of yesterday, it is still a very active investigation.
Thank you.
Thank you, Ms. Bailey. We'll hear
Thank
from
you
Ms.
very much for your
Kagawa now.
time.
Good morning, Chief Justice and Associate Justices. My name is Shannon Kagawa, and I am representing the Office of the Prosecuting Attorney. The issue to me before this court is whether the documents that are being requested by respondent choices are requested, State believes that they're privileged. And you have brought up, Justice Stevens, earlier, are the Schweitzers still suspects? So I'll get right to it. Yes, the state still believes the Schweitzers are still suspects in this crime. And I am not, it is an active, ongoing criminal investigation. I know you mentioned the joint stipulated facts. Yes, the state agreed to the joint stipulated facts, as those are facts that came out during the trial as facts being presented at the time, and that was based on the Rule 40. But as far as whether or not they're still suspects, you look at Sean Schweitzer's own statement, which I believe is in docket 131, as well as docket 130 during his change of plea. There are admissions there as far as what happened or his involvement in
Well,
the crime.
you know, I mean, it's not just the stipulated facts. Didn't you help craft the FOF and COLs with respect to both Sean and Ian Albert?
Yes.
So, and in those FOFs and COLs that the judge signed off on, I mean, didn't you sign off on precluding them as suspects?
I don't believe that's what we precluded them as suspects. We agreed that under the Rule 40 under McNulty that the facts, that there was DNA evidence that pointed to someone else.
Can you
that
tell
it
me
excluded
why would a county prosecutor's office essentially agree to post-conviction relief if they still believed the convicted individuals were still suspects?
Because I do believe under McNulty that the DNA evidence that was received could lead a jury to a possible different verdict. I'm not saying that they would be found not guilty. I'm not saying they would be found guilty. I'm saying that with the new DNA evidence, it would be possible that a jury could reach a different verdict.
A murder has no statute of limitations. Are the Schweitzers going to be suspects, you know, for the next 30 years?
I definitely hope not, but I think we do have to allow the police department the opportunity to do an investigation. As you said, this is a 30-year-old case. I can say that I do know that back when this murder happened with Dana Ireland, Mr. Laurel's name was nowhere in the police report. He
Ms.
was never interviewed. Yes.
I'm sorry, I didn't
No
mean to
problem.
cut you off. Ms. Kagawa, Hawaii Rules of Professional Conduct 3.8c says when a prosecutor knows of new credible and material evidence creating a reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor shall promptly disclose that evidence to a court or authority and disclose it to the defendant and or the Office of the Public Defender. Are you under an ethical obligation, your office, to disclose aspects of this current investigation to the extent they're exculpatory? And if you are, when are you going to comply with that requirement?
Well, for both of them are not convicted defendants. Both of their convictions have been overturned at this point.
So you think it doesn't apply?
I do think it applies, but there is nothing exculpatory that the state has or that my understanding that the police department has at this time regarding this investigation.
To the extent the evidence points to Mr. Lauro as the sole person who committed these offenses, wouldn't it be exculpatory?
And I think if that's what the evidence were to say, that he was a sole perpetrator, but I don't think at this time we are ready to say it. We still, regardless of the fact, we still have the change of plea, we still have the statements made by Mr. Schweitzer. There were statements made at trial by John Gonzalez. There were statements made by Michael Ortiz, all pointing to the facts that the Schweitzers and Frank Pauline were involved in this case.
But that's weighing the evidence. Do you get to make that judgment, or do you have an ethical obligation to turn over the exculpatory evidence?
I agree that I
The
do have.
newly discovered exculpatory evidence.
If
pardon.
there is exculpatory evidence, I would say that I would have to turn something over. But at this time, we don't have anything exculpatory.
Ms.
Could
Kagawa.
you, I'm sorry, could you speak directly into the microphone? I know.
Sorry.
Yeah, thank you.
So, it appears to me really given what you've argued today, we have a criminal matter that is apparently still ongoing. And in fact, the Third Circuit Court judge vacated the convictions, but dismissed the indictments without prejudice, right? That's the technical current circumstances.
That's correct.
The
Yes.
dismissal was not with prejudice, it was without prejudice.
Yes.
So we've got this apparently criminal matter still ongoing. We've also got this question of compensation under Chapter 661B, which is what the Schweitzers are pursuing pursuant to their joint petition. So, I think the question really is how to separate these two and to properly address them in their proper order and space. So can you address that, please?
And I agree. I think this situation is very unique. It's something that I've never experienced, and we weren't sure how, or at least I wasn't sure how to address it. For me, the Rule 40 was that quasi-criminal situation, right? Once the conviction was vacated, at that time, I believe that our office was no longer involved, would have been involved in the Rule 40. When the 661B initiated, I think it first started with, they called it a motion for actual innocence that was originally filed in March.
Within the same proceeding.
Within the same proceeding. Initially, when I read it, when we had discussions, I believed that this was not the proper venue, I guess, for it to be done in the Rule 40, based on how I read 661B, because 661B was quite clear that it said it was a civil proceeding filing with the Attorney General.
That's the statute that allows someone who has been wrongly incarcerated to seek compensation from the state.
Yes, but I guess after discussion, we decided that the belief was, when you read 661B, that there needed to be a finding of actual innocence first. And that's what was discussed, and that's why we kept it in the Rule 40.
And perhaps that is what is the challenge in this case.
Yes, and you can correct me if we're wrong and it wasn't supposed to be filed there, but that's how, at the time, we decided we're gonna try and deal with it based on how 661B read.
And you were served with the joint petition, right?
Yes.
Now, was the AG served?
So if you look at the joint petition, they are on the certificate of service, but they were never a party on the Rule 40. So I don't know.
And doesn't that cause somewhat of the problem when we're dealing with, a 661B and a Rule 40 under 661B-12? You're sort of talking about AGs getting involved, because the AGs then would work in connection with the prosecutors, you folks, and the AGs are ultimately the ones in the 661P prosecuting the case, so to speak. They're the ones that ultimately compensate things.
Yes, and I think that's the quandary we're in now, is if it was solely a 661B and if there was a finding of actual innocence, I think that AGs would be involved and maybe they would ask us for something, but.
So going back, you mentioned they were on the certificate of service with the joint petition?
From what I recall looking at the joint petition that was filed, I remember seeing the AG's name.
But they've never appeared at all in court, right?
Correct.
And have you had discussions with the AGs with respect to the 661B matter?
I'm sorry.
Have you had discussions, because county prosecutors somewhat work hand in hand with the AGs and 661B matters? Have you had discussions with the AGs with respect to this case?
Very briefly, just that they know that this was going on, but for them, they weren't, in their understanding, because it was the Rule 40, they weren't a party to the Rule 40.
Thank you.
Counsel, if I can ask you, I want to go back to the joint stipulated facts. You signed off on that over
Yes.
2.5 years ago. And the evidence developed since then has actually taken you further and further away from the Schweitzers.
I
I mean,
don't,
isn't that
well,
isn't that how the cases progress? It hasn't circled back. It's gone further and further away.
I don't necessarily think so, because even back then when the trial occurred, we always knew that unknown male number one's DNA did not match the Schweitzers or Frank Pauline. The only to me new piece of evidence is now, as of July, we had unknown male number one's identity. Even during the trial, and it was brought up in the Schweitzer's trial, Ian's trial, as well as Frank Pauline's trial, that the DNA did not match the three of them.
But the factual record that you stipulated to, not a disputed factual record, but the factual record, all of that evidence exonerates them. Would you agree with that?
No, I don't believe that.
What parts don't exonerate them? You had the tire marks, you had the bite marks, you had the DNA. What about those three pieces does not exonerate them?
Okay, well, as
If
far as
if you're saying exonerates them, why did you agree to this?
I don't believe that, because it's joint stipulated facts just as to the Rule 40. I wasn't talking exoneration. And to me, whether someone's exonerated, for me, is a word that I would associate with actual innocence. All we agreed, or as far as McNulty, is that it could reach a different verdict. I don't believe not guilty and innocent, actually innocent, are the same thing.
Well, you would agree that the stipulated facts don't point to the Schweitzers.
I
They
believe
point away from the Schweitzers.
I believe those are just facts. As far as the tire tread, I agree that that's what I can't think of his name, but the tire tread expert said that these tire tracks don't belong to the Volkswagen. Now, the Volkswagen was recovered I believe 2+ years later, but I have no evidence that those tire tracks that they found were actually left by any vehicle that was involved in this incident. This happened in Kapoho. It was back then a gravel road. It could have been left by anybody. It took them a while to get to the scene and to find these tire tread marks. As far as the DNA is only at what I refer to as scene number 2, where her body was found. I have no evidence associating Mr. Lara or unknown male number 1 to scene number 1, but I have statements of Sean Schweitzer as well as Mike Ortiz putting the Schweitzers at.
Are you still relying on Ortiz, the jailhouse informant's testimony in this case?
I'm saying that it's still evidence within the case. As far as credibility,
Hasn't his credibility just been undermined left and right, not just in this case, but in other cases?
I don't know about other cases. I do know that he has testified in other cases.
Wasn't there a case in the Third Circuit in Kona that he was going to be a witness? Oddly enough, years and years after this case, you were going to use him again as a witness, but you dropped that case in the Kona court.
I believe that did happen, but those are still facts that were said. I'm not, as far as the weight to be given, that would be a different area, but there's still facts that are in the record.
I mean, there's a difference between evidence and useful evidence, right? Evidence that you're actually going to use because it's credible, and evidence that's just evidence, but it's not credible. I mean, you've made that distinction, haven't you?
Yes, but I think I have to let the police do their investigation. I don't know where their investigation is going to lead. Maybe it will lead that, Mr. Lara.
I don't think anyone's saying that the police department shouldn't do their investigation. I'd be the first to admit that we want a thorough and complete investigation. But the question is, what is being investigated at this point? We're 30+ years out.
And I think
somebody served 25 years of their life, prime of their life, been taken from them, and here we are.
And I agree. But I think that now they have to go back 30 years because, as I said, Mr. Lara was never, ever interviewed, never anything part of the record. Now they have to go back 30 years and find out what he was doing back then, who he may have hung out with, what type of car. It's hard to go back 30 years, I think, and that's what the police department is going to have to do.
All right, Ms. Kagawa, anything further at this time, or would you like to save your time for rebuttal?
I'll save the time for rebuttal.
All right.
Thank you.
Very well. All right, next we'll hear from Ms. Brown. on behalf of Albert Schweitzer.
Good morning, Justices. May it please the court.
Ooh, you're gonna have to
Oh,
speak
can you hear
up.
me?
Thank you.
Okay. Oh, okay. Thank you so much for hearing our arguments today. My name is Jennifer Brown. I'm the Associate Director of the Hawaii Innocence Project, and I, along with my co-counsel William Harrison and Keith Shigatomi, represent both Ian and Sean Schweitzer and their post-conviction matters. Since we will all three be arguing jointly together, we have divided up these issues before the court. So I will be, again, like to focus on the applicability of the UIPA in this case and the ongoing investigation. And my co-counsels will be happy to discuss the issues of the Rule 40 and the other supplemental briefing issues that you asked us to present to the court today. So why we are here, I don't really know the answer to that question. One would think that after Ian and Sean convictions were vacated 24 years after their wrongful convictions, and we continued, we being the Hawaii Innocence Project, along with the Innocence Project of New York, continued to still assist the prosecuting attorney's office in the Hawaii Police Department, as we had since 2019, and still identifying the person who is responsible for the murder of Dana Ireland. This is even after their convictions were vacated. And we continued to share that information. But at some point after their convictions were vacated, there seemed to be a pushback from the state, no longer wanting to cooperate with us. And we believe that was because we were seeking a finding of actual innocence, which would mean that the state would have to compensate both Ian and Sean for the wrongful convictions. And at that point, we were still willing and able to share that information. We hired Stephen Kramer, who was a former FBI. He was the one that identified the Golden State Killer. And he helped, with the help of genetic genealogy, actually found within a few days, this is back in February, a suspect. That suspect turned out to be Albert Loro Jr., who back in July, his DNA was taken on an abandoned fork. Then furthermore, once we learned that he in fact was confirmed to be unknown male number one, then we then asked the prosecuting attorney's office and the police department to please ensure best practices were taken, because again, we feared that the investigation, knowing that he had evaded justice for 33 years, that he could destroy evidence, that he could flee. We do know that we do have belief that he did flee at one point to the state for quite some time after the crime occurred. So that was a concern of ours. And we also worried that, you know, if the police did interrogate him, whether that would be recorded. We also were concerned that someone who has evaded justice for 33 years would maybe take their own life. And so we asked...
I understand what you're saying, your concerns, and I think that's come across in some of the briefing. But really, isn't this 661B matter that you're seeking, which is now the compensation, it's been filed in the Rule 40 case, like Justice Ganoza mentioned. And isn't there a problem or a difficulty with respect to that posture?
Yes, I would say that it is a challenge for sure. It is something what has required multiple chambers conferences with the judge to figure out what is the appropriate posture. I do know that my co-counsels have thoroughly briefed that issue and are prepared to present that argument. So I would like to defer to them for that specific question.
Okay, and I noted you mentioned you were going to talk about the 92F issue. I think you might have heard some of our comments earlier with respect to that. I mean, are you going to forward on that issue, or are we going to hear from you?
Yes, so I think I think that this court is quite correct that it doesn't apply to the Schweitzer's request for this evidence, saying that it is a pending court case. But we would like to also put on the record that we are not only just seeking that this information be released to the Schweitzers, but that it be released publicly. The Schweitzers have had their reputations. They have been accused of being murderers. There was even a wanted dead poster that was hung around the community when this trial was going on. And they have, the public has a right.
Let me, you know, when you say it should be released publicly, are you suggesting that the court would not have the power, if it's working under the HRCP framework, to do a protective order that would limit the documents to this particular case, or fashion any type of protective order that it deems appropriate?
I yes, that would be a possibility. I do believe, though, that in Judge Kubota, in his order, he indicated that he had reviewed the documents in camera. He did not believe that anything would threaten or harm any pending investigation, especially because Mr. Loro is deceased. And so we would believe that, again, this would be an issue before Judge Kubota, but looking at those documents, I think the court would be required to release the documents to the extent that it doesn't impede their current investigation, but it does allow for them to release certain things, clearly exculpatory information that we can use for our claim of actual innocence. That should not be held from the public. The Schweitzers have a right to have the public know why they are actually innocent, and any information about Mr. Loro that which further prove that issue.
What about the timing? Could the court decide to release the documents to the Schweitzers but delay releasing them more broadly in order to balance the conflicting interests of a law enforcement investigation with the Schweitzers' right to seek compensation?
I think that is the confusing part to us. So originally when the chief of police, and again, they choose their opportunities of when they want to release information to the public and when they want to withhold it, right? When they gave his press conference, he indicated that they would only need 2 to 3 weeks to complete their investigation. Now that's been even weeks and weeks and weeks before when they filed originally to withhold this information. It's been 7 weeks since then. It's been 7 months. They had 7 months from the date in February when we identified Mr. Loro as a suspect to start investigating him 7 months ago. This case is also 33 years old. So, and they should be very well aware of the record. So I don't, the Schweitzers have waited long enough for justice. I mean, even Carl Rhodes stated that the purpose of 661B is that they should be able to walk out of the door of the prison and get that money that next day. And it's already been coming up on the 2-year mark. And although our best efforts, we don't believe that because we did identify the person that is responsible for this crime, it should delay it any further. I would think the opposite, that it should speed up the process. Because I do not agree with what the prosecution has stated so far in court today, that the Schweitzers are anyway suspects in this matter. They always had a fourth perpetrator theory. We disputed that in our Rule 40 criminal post-conviction proceedings.
Well, let me ask you, do you have any reason to believe that the police department isn't using their best efforts to track down the rest of whatever leads may be out there to tie up any loose ends? Do you have any reason to believe they're not trying to do that and using their best efforts?
Sure. Well, the declaration that was attached by the police officer, I think, indicated that one of the reasons for delay was because somebody was on vacation. If the interest was...
Those things happen, but other than that, do you have any other reason to believe that they aren't in earnest trying to put an end to this?
Well, I believe that Ms. Kagawa stated that it sounds like his family members are not cooperating with police and do not want to be interviewed.
Which may shorten the investigation.
I would hope so. But at some point, continuing to allow this matter to just keep going into the future because there's some sort of pending investigation, arguably anyone that is wanting to file a petition under 661B, the state, all they have to do is say, well, there's a pending investigation still. We still believe that they're suspects. And then they just wait until the statute of limitations runs out, if there is a statute of limitations in that case. So I think the burden should be on them to provide us the documentation, whatever is exculpatory, and provide it now. And then the court allow Judge Kubota to weigh the evidence. He said that there does not appear to be anything in the documents he reviewed that implicates our clients. If anything, it further supports their claim of actual innocence.
Which is an issue that can be taken up in a separate 661 Bravo proceeding, correct?
I'm sorry?
It would be a discovery dispute under 661 Bravo and that type of action. It would be a discovery dispute. And the trial court could rule on it in that separate action. But
to get to 661, that separate action, we still need a finding from the originating court that vacated Mr. Schweitzer.
I understand that's your understanding and the confusion that surrounds that. Thank you.
All right. Thank you very much, Ms. Brown. Next, we'll hear from William Harrison, also on behalf of Ian Albert Schweitzer.
Good morning, Chief Justice and members of the court. I think the court has hit on the problem in this matter, and that is this: 661B1 was inartfully drafted, and unfortunately, it's a law that we have. So what we did in this case is clearly use the only vehicle we could to actually address the important issue that has to be determined before we can go forward on the 661B1, and that is actual innocence. So we had two parts to the Rule 40 petition. The first part was obviously getting Mr. Albert Ian Schweitzer out of custody, and we submitted a writ of habeas corpus for that purpose. The court found, based on, as you folks have agreed and saw, joint stipulated facts, that he was not given a full and fair opportunity to present his case. And on top of that, there was newly discovered evidence that conclusively proved that he was not involved in the matter. And I think that's absolutely clear here. Otherwise, the state would not have agreed to that. So what do? We filed under Rule 40. And under Rule 40, the court has the opportunity to actually give us the discovery that we actually need in this case. And the discovery need here is the additional information that was given to the police department relative to Mr. Laurel's passing, any information he gave prior to his passing. And we have reason to believe that some of the information that was given prior to his passing was that our clients he did not know our clients at all. Okay, so the state continues to say that our clients are suspects in some respect, and their whole case was premised upon 4 individuals in a Volkswagen going down a fishing trail, in this case, carrying the body of the decedent. And we proved that our hearing in this matter, a Rule 40 petition, that was not possible based on what happened and what was recovered during the course of the investigation. So under Rule 40, the 40 paragraph F indicates a petitioner shall have a full and fair evidentiary hearing, receive all evidence that's relevant and necessary to determine the petition. And under paragraph G, it also states that the court has the ability to issue such supplementary orders as may be necessary or proper. And that's what we're asking the court to do in this case, and the court actually ruled on those. Now, Chief Justice brought up a very important issue here, and that is this. Not only does the state have the requirement under the procedure that we pursued, but also under HRPC Rule 3.8, and the commentary is really telling here. The commentary indicates that a prosecutor has the responsibility of administrative justice, right? And not simply that of an advocate. And it goes on to say later on in that paragraph, and to rectify the conviction of innocent persons. That's basically what we're asking the court to do, is impose upon the state in this case the obligation of giving us any evidence they have obtained after we provided the suspect to them, what that suspect told them, and what happened during the course of the interview of the suspect. And we had asked the court and also the prosecutors in this case to make sure that they followed proper protocol when they actually arrested this individual, if they were going to arrest him. And that did not happen. And the fears that we had raised early on came to fruition. He committed suicide. And we could say, can be argued, that what's the most damning basis for guilt is someone under these circumstances committing suicide. And so all we asked the court to do was to require that evidence to be brought forth to the court. We asked the court to be the gatekeeper. We asked the court, if the court found that this information that was given over was involved in ongoing investigations, that the court could in fact restrict that from us, redact certain information so that that would not violate any concerns of the
Mr. Harrison, the action you seek under 661B damages on behalf of your client, correct?
We do.
Okay, and that is a civil action.
That is a civil action.
So what we seem to have here is civil claims being brought in a criminal proceeding, and there's a sort of a mismatch between the claims and the rules applicable to that proceeding.
Actually, no, and one of the things that happened during the course of some of the arguments that we had before the judge was that very question was put to me: are we in a civil situation or we're in a criminal situation? And I misstated that we were in a civil situation because upon reflection, we are not in a civil situation. Unfortunately, 661B does not give us the vehicle or the definitions as to how we are to obtain, or the procedures as to how we are to obtain that judgment of actual innocence.
Well, isn't that really then a problem with 661B and Rule 40? Because you say you're not in a civil case, but I look at your joint petition, it's styled like a civil complaint. You got counts, you got jurisdiction. It's filed pursuant to 661B. I mean, it has all the hallmarks of a classic civil complaint. And you did argue at that hearing civil discovery.
I did make that statement, and I'm taking that statement back at this point in time, because upon reflection, we are not in the civil realm as of yet.
So why are you resisting, it seems, a 40C3 fix to this?
Well, I'm not resisting a 43 fix if the court wants to use a
well,
43.
I saw that in your joint response. Didn't seem to be eager to go down that path.
Well, our position is that we are still in the Rule 40, so we can go down that path, and we probably should go down that path at this point, because that's the vehicle for us to make that final determination of actual innocence, is the Rule 40. We may have stylized our joint facts with 661B in mind, but that was not the vehicle that we're going to use, because the statute doesn't allow us to do that. We ultimately have to file a civil claim down the line, with, as everyone knows here, the correct party being the Attorney General's office, because basically they hold the purse strings. Okay.
Counsel,
Yes.
when you folks filed the joint petition, at that point in time, the Guidi case had been issued by the Intermediate Court of Appeals, and that case, it's factually underlying, is a little bit different, certainly, but that case says, it holds that you don't actually have to have the words factually innocent or actually innocent in the criminal proceeding in order to pursue damages under Chapter 66B.
Correct.
So why do we need to do this in a Rule 40 petition?
Well, the unfortunate thing is that when the judge issued his order, he issued it as a dismissal without prejudice. And I think that really puts a wrinkle in how we proceed on this matter. And in fact, in one of the exhibits that's before you, and I don't recount the exhibit here, the Attorney General actually sent us a letter back, basically saying that you cannot come to me until you get a decision by the court of actual innocence.
I thought that was referenced in the petition, in the joint petition.
And so we are trying to cover every one of our bases so that we can resolve this favorably on behalf of the Schweitzers.
Well, one of the things I think about is that this is not that different than, civil litigation where, for instance, a civil litigation that arises out of a criminal circumstance where folks want to move forward on the civil proceeding to seek damages but there is a criminal matter that's still ongoing. In my experience, the civil action is stayed, not forever, but at least for some reasonable time that the civil judge determines to allow the criminal matter to come to a reasonable conclusion. So why is this different?
Because we've had a partial decision by a court saying that our clients are exonerated. However, that decision left the door open for the Attorney General's office to say this is not in the civil realm as of yet because you've got one final piece you need to get, and that is a declaration by the court. And so we're a little bit different than a situation where we've got criminal case going and a civil case going. We don't have a civil case going at this point because—
But Counsel, Rule 40C3, doesn't it, I mean, 661 Bravo is a separate cause of action, right?
Correct.
Okay, and under Rule 40, it requires, it's a shall be transferred to a different proceeding.
And that's that point is important because what the state had the obligation to do in this case, if they believe it really was a civil matter at this point, they should have moved the court to move that specific portion of the case to the civil courts. They never did that. So they,
Or
in
you could have moved yourself as well.
we could move ourselves. We don't.
But let me ask you this. When I looked at Judge Kubota's findings, his conclusion 6 says, based on the newly discovered evidence, that he feels that it conclusively proves that a new trial jury would likely reach a verdict of acquittal. Isn't that enough for you to folks move on to the 661B proceeding at that point? Did you consider it as being sufficient, or?
We still, because of the fact that, as the state has pointed out, this case was dismissed without prejudice, and they still believe that our clients are suspects, even though there's not one shred of evidence that suggests that they were involved at all in this case. And so in order for us to proceed, we decided to cover all of our bases, in effect. And the court, if the court's going to determine actual innocence and willing to determine actual innocence, which the court indicated it was willing to hear in this case, we're going to go forward on it.
Mr. Harrison, looking at your 6650, your petition, I see what you're arguing now. It does say that you were seeking a finding from the circuit court that they are actually innocent and order that they be compensated per 661B. So why couldn't we just handle this under Rule 40C, which says that where petition seeks relief, pleads a separate claim under a statute, like a civil claim, then the latter claim or claims shall be ordered transferred by the court for disposition under the civil rules. So in other words, we order that the 661B petition, which is supposed to be a civil petition, be filed in a separate case, but that your request that the circuit court find your clients actually innocent remain under the Rule 40, which allows for supplemental relief.
Okay, you're absolutely correct in that. And depending on what this court orders, we may go back to the court and seek that relief.
Very well. Anything further at this time, Mr. Harrison?
No, thank you.
Very well, thank you. Mr. Shigatomi, on behalf of Sean Schweitzer.
Thank you. May it please the court, Mr. Chief Justice, Associate Justices, I'm Keith Shigatomi. I'm representing Respondent Sean Schweitzer. And you shall know the truth, and the truth shall make you free. For nearly 33 years, the Hawaii Police Department couldn't find the truth. And now they can't handle the truth. Because the truth is, they falsely prosecuted 3 innocent men. And when they had the opportunity, they let the actual perpetrator escape prosecution. So what this case is about is we have filed in separate cases initially, Rule 40 petitions. And in Sean Schweitzer's case, he asked to vacate the conviction or to withdraw his plea. State stipulated to a withdrawal of his plea, which, as this court knows, requires a finding of manifest injustice. So they agreed to it. No matter what they say about what Sean may have pled guilty to, what is contained in his statement, they agreed to allow him to withdraw the plea. After that happened, we went to court. They filed a motion
to or to nullify prosecute the case. Their motion, court granted it. Dismissal without prejudice. So then we've looked at the provisions of 661B and say, well, we know on its face, it says that this court decision has to state that the reversal or the vacating of the judgment was based on actual innocence. That's all we know. Now, I understand, Justice Ginoza, that there is the Guidi case. And the Guidi case says, well, we know that that's kind of making it too specific and we can avoid compensation by just simply omitting those words. So if it's an absurd result, we're not going to enforce it. But we don't know how to enforce it at this point. I know that Guidi is up on certiorari. I know that Alvin Jardin's case is here. So we're still kind of left with the situation is we have to look at the plain reading of 661B, which says the court decision has to state he's actually innocent.
You don't strike me as a strict textualist, Mr. Shigetome. Giddy did come out.
Yes.
Okay, so, yeah, and I certainly understand the dilemma faced here because, as I mentioned, 661B and Rule 40 really weren't designed to provide a procedural framework for these matters. What's your position on whether just the basic structure of a civil lawsuit under the Hawaii Rules of Civil Procedure should govern a 661B matter?
I agree that the rules of civil procedure should govern in a 661B. I mean, that's pretty clear. It's a civil complaint. In this situation, we have the vacating of the judgment. Both Schweitzers have been, the cases have been dismissed. They've been called exoneration. I mean, that's another technical term that we don't necessarily have to define here, but we know that in order, on the face of 661B, they have to be declared actually innocent. So all we simply have done is to go back to the court through the Rule 40 and to say, we want that finding. We can't use it in the Rule 40 for the 661B. I know that's what the petition is entitled, but it was probably mistitled. It's been clarified with the court, the circuit court, that all we are asking for in this further proceeding is whether or not the court is willing to make that declaration that Sean and Ian are actually innocent. If the court does that, then we feel we have the basis to then file the complaint under 661B.
What if the court were to dismiss the charges with prejudice?
If the court was to it's still a difficult situation because the state has argued that an acquittal doesn't necessarily mean actually innocent. They talk about legal insufficiency as opposed to actually innocent. So that's, to me, is a gray area, and that all we're trying to do is eliminate the gray. So once we, hopefully, get that finding of actually innocent, then we can file the complaint, it'll be clear on its face, and at that point, if I was a strict constructionist, I would think they have to pay the compensation.
You know, what's interesting about 661B and what we have been talking about so much with regards to that statute is simply a pleading requirement, right?
Yes.
That the order vacating the conviction said actually innocent. And Guidi said you don't actually have those, you don't need those actual words, right? The decision from the ICA that came out in 2023. But 661B also provides, if you get over that pleading requirement, that you, and if the state contests whether compensation is owed, you can go to trial after that, right? So we haven't talked at all about that. So there is a whole other area of 661B that actually deals with the question of whether someone was actually innocent.
Okay. And my position is that the best person to make that determination at this point is the court who heard the Rule 40 petition. The court heard the Rule 40 petition, heard evidence, reviewed all of the transcripts, made specific findings of fact, state agreed to, conclusions of law, and that judge would be in the best position to issue that.
That may be, but when you're dealing with the kind of challenging discovery issues which is what brought this case to this court, the civil procedure rules seem to be much better suited to deal with these types of issues. We haven't talked much at all, actually, with you about what kind of privileges would apply and how we go about dealing with those issues. So can you address that, please?
Okay. First of all, it is incumbent upon the party who's claiming the privilege to assert it. And they've talked about 92F, and our position has been that 92F does not apply. So if you look at what they actually filed in circuit court, they asked the court to quash the subpoena, or in the alternative, to review the documents in camera, make a finding as to what is relevant to the proceedings, and to issue a protective order. Judge Kubota, in his order, or his order says, I'm going to take the materials in camera, I'm going to review them, I will make redactions that I feel that is necessary, and then I will release them with a protective order to the parties, not to the public, but to the parties for the purposes of this litigation. And so Judge Kubota did what they asked for. And now we're still here with them saying, well, he shouldn't have done that. But he did that. He is in the best position, as in any judge who is presiding over a case, to look at the information. All judges will have to make a determination as to admissibility or what is relevant or what is pertinent. And Judge Kubota was willing to do that. He was prepared to do that until they filed this petition at the very last minute.
So at this point, records are with the circuit court judge, but in camera, meaning
Correct.
that nothing has been released to the parties or beyond.
Correct.
Okay.
And it should be noted that in his comments, Judge Kubota said that for 33 years, the Hawaii Police Department didn't have a clue as to what happened in this case. And in the documents that he reviewed, everything pertained to Albert Laurel Jr. Nothing else about any other suspect. I'll also note that on July 29th, the state filed a motion to continue the hearing, saying Hawaii Police Department is still conducting investigation. We need 3 weeks. We've gone past 3 weeks. We're double that. Now they say they're still conducting an investigation. I don't doubt that they may be doing that, but for what purpose? Other than to say we're conducting an investigation. 1991 is when this case happened. That cell phone is not going to give you very much information as to what happened in 1991. You may have a photo. We have looked at Facebook photos. We have seen Facebook photos of Albert Laurel Jr. fishing. But other than that, it's not going to tell you who he was with on December 24th, 1991.
Well, it might tell you somebody who he called after he was interviewed by the police. I imagine that's what they're looking, or
Well,
what they're looking for. Who did he call? Who did he think might be interested in the fact that he'd been contacted?
Okay.
That may not lead anywhere, but I think they're saying, let us have that opportunity. What's your response to that?
My response to that, Chief Justice, is this case has been all over the news for 30-something years. And everybody knows that they were trying to find what happened to Ms. Ireland. And if they had known something or they suspected something, they certainly would have said so. There were reward posters all over the place. Rewards were collected. So 33 years later, somebody's going to now come forward and say, I knew that Albert Laurel Jr. was involved. No, we told them he was involved. And after we told them he was involved, they let him commit suicide. And that's why we're here today. All we're saying is we want the opportunity to get the evidence, to present it to a court, and to have the court declare Sean and Ian actually innocent. In 1991, Sean Schweitzer was 16 years old. In 1997, when this case was first prosecuted, he was 22 years old. Here he is now at 49. He wants the chance to remove the stain from his name, from his family's name. All we're asking for is information. If it doesn't prove it, then we fail. But all we are asking for is that information, which Judge Kubota was going to release to us at their request, at their alternative request under their conditions. That's why we're here.
Very well. Thank you very much, Mr. Shigatomi.
Thank you.
We'll hear a rebuttal, beginning with Ms. Kagawa.
He's a little too tall for me. Thank you, Zato. Just really quick. I understand what they're saying. They're wanting the records. The state's position is still always their potential suspects. And the state cannot think of any situation in a case where if someone is potential suspects in an ongoing active criminal investigation, that those suspects can get police reports regarding that criminal investigation. That's, to me, absurd. That's ridiculous. Why would we ever give police reports to potential suspects in an active criminal
So
investigation?
it is your position that since they have not been recharged, this is not Brady material?
Yes, I don't believe it's Brady material at this time, as they're not convicted defendants at this time.
And you're not setting any sort of deadline on when they might get the material? Because you're saying that if they don't, are you saying that once you think that the investigation is completed, you would no longer object to the release of the material?
Well, I guess it would depend on what the material says. I think at that point it would be up to I don't think the public should get it, but if they need it for their actual innocence, and maybe it's through the civil proceeding rather than this Rule 40 hearing, then that is possible. But until the investigation is complete, until the police have tied up the loose ends, can either include them or exclude them, I don't think anything should be given.
How do you respond to Mr. Shigetomi's statement that on July 29th, the county said they needed 3 more weeks?
That's correct, Your Honor. When we asked for 3 more weeks, at that point when we asked for the continuance, the detective, I believe at the time, was on vacation. And at that point, it was just trying to get the records and things and hoping people would cooperate.
On July 29th, you made a representation of 3
did.
more weeks. Obviously, that time has passed, and now you have no deadline.
I don't have an exact deadline of how long it would take them. That's correct. I do say that we said 3 weeks, but I'm not sure if within the 3 weeks that I requested, if their investigation then led down another road, and then that's where it's going.
Why not have produce the materials under a strict protective order that would limit initially, not forever, their access to the claimants, I guess in this case, defendants and their counsel? In other words, wouldn't that balance the interests in protecting the investigation with allowing them to move forward and seeking compensation after such a long period of time?
The concern is, at this point, we still don't know whether they are. For the police department and for our office, they're still potential suspects, and I can't see releasing it at this time.
And are you going to provide the court with information about why they're potential suspects, or is it pretty much what you've already cited, which is simply the evidence that was already in the case?
Yes.
It's the evidence already in the case.
Correct. I don't have any further information as far as what's happening in the police investigation.
All right.
If Lauro made statements saying he doesn't know the Schweitzers at all, never met them, they had no involvement, I mean, how would that jeopardize or compromise the investigation?
So I understand. I believe that if Lauro had stated, I did it all by myself, nobody else was involved, yes, that's different. And that's something I would agree.
Well, there may be others involved, but if he says the Schweitzers definitely weren't involved, I mean, why would disclosing that be a problem?
If that's what was said, I would say that I would disclose that, but without saying, I don't believe that that's the information that was given. I don't believe that Mr. Lauro made a statement that said, I'm the one who did it and nobody else. The Schweitzers were not involved.
Thank you.
Very well. Anything further?
Nothing further. Thank you for your time.
Ms. Bailey, your rebuttal.
Thank you. I wrote a number of notes here during all of the testimony that was provided, so I'd like to backtrack a little bit. Ms. Brown was mentioning there was discussion about 661B. HPD asserts that the 661B petition was improperly filed in the Rule 40 proceedings, which has created kind of the procedural and rule free-for-all that has happened in this case.
Would you have any objection to the court ordering that it be transferred per Rule 40C?
I'm sorry, I didn't
Rule
hear.
40C is very clear that if there are civil claims under a statute, those claims should be transferred to a new civil proceeding.
Correct.
Yeah, like transferred to the civil court.
Correct. And 661B states that as well, and it should have been. And then the Attorney General's office would have been involved and properly served, which they weren't. They were on a Jeff's notification when the 661B petition was filed, but they were never personally served. At least to my knowledge, it does not appear that way. Ms. Brown also mentioned that Ms. Lauro was not cooperating. That is absolutely not true. She is cooperating. She just lost her husband of a number of years and is also trying to digest what has happened in this last month and a half. So she is cooperating. She just needs time.
Was it Ms. Brown that said that she wasn't cooperating?
I don't know.
I think she was repeating what Ms. Kagawa said, perhaps.
That Ms. Lauro, that there were non-cooperating witnesses. I believe one of the respondents mentioned that. And I just wanted to clarify that point. I also, Mr. Harrison mentioned that this did transfer under the rules of civil procedure within the Rule 40 proceeding, which again, we believe is improper. The Office of the Prosecuting Attorney doesn't handle civil matters. If the 661B were filed in the Rule 40 proceedings, either the Attorney General needed to be served properly and handled in that regard, or the Office of Corporation Counsel would have come in much earlier to this case. Mr. Shigatomi, and I believe Mr. Harrison also stated that the rules of penal procedure apply. And again, I think as we all have recognized, under Chapter 661B, it's a civil remedy and the civil rules apply. And
Counsel, I'd like to ask you one question, which is, I mean, you agree there's no absolute privilege for police investigations, correct?
Correct.
Okay, and maybe I'll ask you two questions. And that's recognized under the prior case law of the
Correct.
state. All right, thank
Correct.
you.
And what I would say, regarding the protective order, I think it's a great idea. And the lower court, in the motion to quash, when it was denied, advised this council to go to the respondents to request the protective order. I did reach out and I tried to see if their clients would be open to that. And one of the respondents never got back to me. One said they would be open to it, but obviously the protective order would need to apply to disclosure of the records for both of the Schweitzers.
Ms. Bailey, this is your writ, and from what I gathered in your comments as well as the writ itself, you're essentially saying it's a flagrant and manifest, abuse of discretion, because of the time frame, the quick get us the stuff, within a couple days.
Right.
Can you elaborate on why you think this was a flagrant and manifest abuse of discretion?
I can. I think you started with the quick time frame. I mean, we literally were served on a Thursday, had to file a motion to quash on a Friday, and the hearing was on Monday morning following that. And then when the Hawaii Police Department raised the issues regarding the ongoing criminal investigation, and provided to the court exactly where the investigation was at that point, obviously in its infancy, literally trying to identify friends that would have been friends of Mr. Lauro 30 years prior that may know something. That what we received back from the lower court was that, Mr. Lauro, you're not going to prosecute a dead person. What are you possibly investigating? And if you look at the subpoena dulcis tecum and what it requested, that's exactly what was being investigated. So what they requested from the Hawaii Police Department were the very items that were currently unfolding right before Hawaii Police Department's eyes. They were currently being I mean, the autopsy results obviously weren't back at that point. Cell phone analysis was not completed. Witness interviews had not been conducted. They were trying to identify witnesses at that point, people that may have been hanging out with Mr. Lauro at that time, reaching out to family members, finding family members that are strewn throughout the country to interview them. So in that regard, I would say that that was an abuse of discretion to reach an ultimate conclusion that Mr. Lauro must have been the one that sexually assaulted, kidnapped, and murdered, all by himself, Dana Ireland, without allowing the police department to complete its investigation into the recent developments. I want to circle back to HRS 92F. And what I will say, and I need to clarify and correct a piece of my supplemental brief in terms of its relationship to Hawaii Rules of Evidence 501. I would say that the 92F doesn't in and of itself create a qualified privilege, such as the law enforcement privilege that's not only recognized in case law in the state of Hawaii, but recognized nationally, to maintain the confidentiality of records that are related to an active criminal investigation. But the law does support, and the reason I'm clarifying and correcting is because I've been continuing to research even after that supplemental brief was filed, is that the law does support that where there are discovery privileges that are parallel to the exceptions found in a model code such as UEPA or the Freedom of Information Act, that balancing test should be combined with the policies that underlie those UEPA exceptions. I don't think we can ignore the UEPA exceptions. They're there for a reason.
Are you arguing that UEPA modifies what folks are entitled to get in civil discovery? I thought it was actually sort of the opposite. There's a recognition that parties to litigation can't go file a UEPA request to get something that they otherwise wouldn't get in civil discovery, but civil discovery is very broad, entitled to any relevant evidence.
Right.
Subject to privilege.
Correct, subject to privilege. And what I would say is that the policies that underline the exception to UEPA need to be considered within the balancing test under the privilege of Hawaii Rules of Civil Procedure.
What's your authority for that?
The case law. Friedman versus Halsey, 738 F2D 1336.
One more time, please. 738.
738 F2D 1336, DC Circuit Court, 1984.
Right, but the federal courts are very clear that the law enforcement investigation privilege is a creature of common law. It's all the cases say that. And so therefore, but Rule 501, we've indicated that Rule 501 has abrogated any common law privileges.
Correct.
And so a privilege needs to be under the Constitution, such as the privilege against self-incrimination, or under a statute. And I don't see a statute.
The law enforcement privilege was codified, and I'll call it the law enforcement privilege. And basically what I'm discussing here is the ability for a police department to maintain the confidentiality of records that are related to an active ongoing criminal investigation. That was codified in the Freedom of Information Act under the exceptions. And I would argue that those were also codified.
What subsection are you citing to? What statute are you citing to under 92F?
Under 13-3.
13-3.
Yeah, 92F 13-3. I would argue that if we did enough legislative research, that those exceptions that are found within 92F-13 were also the codification of the common law enforcement privilege.
Well, I might invite you, since you're back to doing some research, to go look at Peer News, and there's a nice footnote in Peer's News with respect to privilege, and 92F.
Thank you. And I would recognize, I do know that there are two separate discovery mechanisms. So. Thank you.
You've gone a bit over, so is that anything further for the court at this time, or is your argument complete?
Just that we would respectfully request that the confidentiality of these records be maintained until the police department has an opportunity to complete their investigation, specifically into those recent developments. We are not asking for an absolute privilege to keep them confidential in perpetuity, but we are requesting strongly that the police department be able to complete their investigation into these recent developments. Thank you very much for
Very
your
well.
time
Thank you,
today.
Ms. Bailey. Thank you to all of our attorneys today for your arguments. The court will take this matter under advisement.
E ku iluna, please rise. Ua ho'oku'u ia mai nei kea aha ho'okolo ki eke hanohano o ka moku aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.